This is a summarization of Chapters 7 and 8 from the publication Tenants' Rights in New Jersey, copyright 2014, a legal manual for tenants in New Jersey. Enjoy. First, we will begin with Chapter 7, Rent Increases. Tenant rights when rent is increased. Landlords only can increase rent if old lease agreement is ended and a new agreement is created at the increased price. Increase in rent has to abide by rent control limitations, cannot exceed that amount. Correct way to increase the rent. A lease of 1 year does not allow an increase of rent during that period of time. Landlord has to wait. Landlord must offer option of entering a new lease to tenant at end of lease, which could be a higher rent. Notice terminating lease and notice of rent increase. Proper written notice must be given. This informs tenant that the lease is ending and that they can stay by signing a new lease. Monthly lease requires a month's notice of increase. Yearly also requires a month. Without notice, you don't have to pay the increase. If you don't pay the increase, landlord can try to evict you in court under the Anti-Eviction Act. This is where you can argue that the landlord did not give proper notice of an increase, and then you do not have to pay the increase until the right notice is given. If they did give notice, you will be evicted unless the increase is unconscionable or exceeds the rent control. Unconscionable rent increases. There is no stated or definite unconscionable rent in percentages or dollars if there is no rent control. But if the new rent is wildly more than the previous rent, or the landlord has increased the rent too many times, it is at a judge's discretion as to the definition. Burden of proof. Up to the landlord to show that the rent increase is fair. What does the landlord have to prove? The large increase is justified. Expenses are more than rental income. Making insufficient profit. Amount of proposed rent increase. How the existing and proposed rents compare to rents in the same area. Who has more power in the relationship? What is conscionable for an increase? Spreading out the cost of a maintenance repair that isn't required by health or housing codes. Rent control. Ordinances allow landlords to automatically increase the rent by a certain percentage each year. This is called annual increase. Ordinances allow landlords to apply the rent control board for an increase above the annual amount. This is called hardship increase. This increase is in addition to a regular increase. Challenging a hardship increase. At hearing, landlord will show and explain why they should get the increase. You can argue about this. The landlord should not recover some of the costs being claimed. Look over every item to make sure the increase is fair and reasonable. Make sure landlord is reporting all income. Goal of the tenant is to convince the rent control board that the landlord is not suffering hardship and that the increase should not be validated. Illegal rents under rent control. You can file a complaint if your rent is higher than the rent control rent. You could get the rent lowered and receive compensation for the illegal rent that you paid. Rent increases due to condo or co-op conversions. If taxes are increased, an increase in rent may not be justified. Increase to retaliate or get even. Revenge for a tenant reporting a violation of health, housing, or any codes is not a reason to increase rent! Last but not least is Chapter 8, the nuts and bolts of fighting evictions. The tenant's right to court process. Tenant evictions may only take place after a Supreme Court judge orders it. The tenant does not have to move out simply because the landlord tells them to or threatens to evict them. The landlord must have sued the tenant and won in court in order to have a legal eviction on their property. An illegal eviction is now a disorderly person's offense. A lockout or eviction is unlawful if it is not done by a special court officer with a legal court order. Self-help evictions by a landlord are illegal. If a tenant is locked out or evicted by the landlord or not by a special court officer, or if their utilities are cut off by the landlord, or if they are molested in some other fashion as an attempt to force them out, it is advised to call the police. The police are supposed to make sure the tenant gets back into their apartment under these circumstances. NJSA 2C33-11.1 period. The new law requires the police or any other public officials who find out about an illegal self-help eviction to warn the landlord or his workers to stop. If the landlord tries to keep the tenants from going back in after a lockout, the police must stop the landlord. Before the special court officer can do the eviction, they must give a copy of the warrant for removal to the tenant or leave a copy on the tenant's door at least 3 days before coming out to do the actual eviction. If a special court officer does do a legal eviction, they must fill out a new form called an execution of warrant for possession. The new form must say when the legal eviction took place and give the name, signature, and position of the special court officer who did the eviction. The special court officer is required to immediately give a copy of this new form to both the landlord and tenant, or a member of the tenant's family, and also to post it on the door of the dwelling unit. Holding your property for rent. NJSA 2A33-1. It is against the law for a landlord to hold or take your clothing or furniture to force you to pay rent. This is called a distraint, and it is illegal, even if you owe rent to the landlord. Hotel and motel residents. Guests in hotels and motels do not have to be taken to court to be evicted. Their hotel owner or operator can lock guests out of their rooms if they don't pay their bills or disturb the peace. The legal eviction process. The only person that can legally evict you is a judge. The landlord must prevent justification pertaining to the Anti-Eviction Act for the eviction of their tenant at a court hearing. Eviction notices. The landlord must supply the tenant with numerous notices leading up to the eviction. However, notices are not needed if the eviction is a result of failure to make payments for rent and can go right to court to file for eviction. A public housing landlord must supply the tenant with 14 days notice prior to eviction. If a tenant does not owe money but is failing to comply with something in the tenant/landlord agreement or doing something that the landlord sees as misconduct, the landlord must provide the tenant with notices of cease and to quit before bringing them to court. Notice to quit is a notice explaining the termination of the tenancy. Time required before eviction suit. The Anti-Eviction Act requires the landlord to give a certain period of time before filing a suit in court to evict the tenant. Examples of this include 3 days notice for disorderly or destroying property, 1 month notice for breaking lease rule or refusing to accept a change in the lease, 2 months notice if landlord would like to move into your rental space, 3 months notice if the space is breaking code violation, 18 months notice to permanently retire the apartment building from residential use. Going to court. The tenant will receive a summons to attend court attached with the complaint. Information about tenant's rights will be served with the summons. The summons must be delivered before 10 days of the court hearing, or the hearing can be postponed. If the tenant fails to show, the judge will enter a default judgment against them. This means the landlord will have the right to evict you just because of your lack to appear at the court. If the landlord does not show, the case should be dismissed. The tenant should stay in court until permission to leave by a judge or court official is granted. An agreement can be settled before the court hearing, but it should be noticed that this agreement must be in writing for it to be valid, in case they try to evict you again in the future. Mediation is required in eviction cases before a judge will hear the case. This means the tenant and landlord must first meet with a law clerk and other court workers in attempt to settle the case. Defending your case in court. You must be ready to show the judge why you should not be evicted. This includes showing the judge the proof to back up your defense, like documents, photographs, and the testimony of a witness. The hearing. The hearing is the time the judge will listen to the witnesses and read documents for your case. The landlord and their witnesses will go first. The tenant has the right to examine the documents the landlord has given the judge to verify what the landlord says they are. The judge's decision. The judge commonly announces his decision immediately after the hearing of the evidence. If the tenant wins, the case will be dismissed. This means they will be capable to remain in the rental unit. If the tenant loses and the ruling is in favor of the landlord, they will have the legal right to remove you from your house or apartment. The eviction will not happen right away and takes time to complete.
This is for every floor search. Houses.